Hi, everybody. Today's Facts in 5 video is another segment in our How to Read Legalese videos that we've been doing here. And this one specifically is directed at how to read your last will and testament, or sometimes people just call it your will. So we're going to go over some of the key terms that you're going to likely see in that document, as well as some provisions that are likely going to be included as well. So for the key terms, the first one you're going to want to know is testator, or sometimes testatrix. So the testator is the male version, testatrix is the female version of the term. But for both the testator or the testatrix, whichever term you're using, it's the person who's writing the will. So if it's your will, you are the testator. Next is the executor. The executor is going to be the person in charge of submitting your will to the probate court after you pass away, submitting any necessary documents to the probate court, and also just basically ensuring that the assets in the will where you've directed to go to certain places, the executor is going to make sure that they get there. The beneficiary is the person who is receiving distributions under the will. So if you say, I leave everything to my spouse, or I leave these assets to my children or my niece or my nephew, those people you're leaving the assets to are the beneficiaries. And then lastly is the estate. So the estate is the term for the assets that are passing under the will. Please be aware of the distinction between what's known as the gross estate and the probate estate. Because if you've watched any of my other videos, you know that the will is only going to direct where certain assets pass, not all of your assets. The only assets passing under your will are individually owned assets, so assets just owned solely by you. Any assets that are passing to a beneficiary under a beneficiary designation, so like a life insurance policy or a retirement account, investment account, any type of financial account where you filled out a form that says when I pass away, the money goes to my spouse or to my kids, those assets are not going to be passing under the will and are not part of the probate estate. Similarly, any assets that you have that are jointly owned with somebody else. So if you own your house, for example, joint with your spouse, when you pass away, the house is going to be included as part of your gross estate for tax purposes. So the state always wants to know for tax purposes what assets that you own. So the gross estate is going to include your joint ownership interest in the house and is going to include those beneficiary designated assets. So they are part of the gross estate, but they're not going to be part of the probate estate. So they're not going to be distributed under the will because, again, they're just passing outside of that probate process. And that's all that the will is for, is dictating where assets that are going through that probate process are going to be distributed. Key provisions that you're going to see in the will. So not every will is going to have all of these provisions. These are just some of the most common ones that we see. So I'm just going to run through those. A lot of times there's a paragraph or a section that covers the disposition of various tangible personal property items. So personal property is, think of things that are around the house. Furniture, furnishings, jewelry, appliances, clothing, tchotchkes or other sentiment, photo albums. Those are all personal property items. Cars too typically fall into that category. So there might be a section that just specifically deals with how those tangible personal property items are going to be distributed. Then there may also be specific devises or specific bequests. And what those are specific instructions for where specific assets are supposed to go. If there's a specific request for where a piece of real estate goes, so my house goes to my spouse or my house goes to my son, that type of specific gift of that asset is known as a devise. If it's I give $10,000 cash to my niece, or I leave my car to my best friend down the street, those are bequests. So it's, again, for both terms, it's specific instructions for where specific assets are going to pass, but it's just they use different terminology. So if it's a gift of real estate or specific instructions as to where a piece of real estate is going to go, we use the term devise. If it's a instruction for where a specific type of other asset is going to go, it's typically known as a bequest. And then there's also the disposition of the residuary estate. So once we've gone through your instructions for where your personal property items are supposed to go and where those specific pieces of real estate or cash or other items are going to go, if there's anything left over, that's the residuary estate. So again, you'll see on my slide there, I just say, everything else that already hasn't been previously distributed under foregoing provisions of the will are included in that residuary estate. A lot of times wills only have a residuary instructions for the disposition of the residuary estate. They might not have any instructions for personal property items or any specific devices or requests. That's pretty common. In a very simple will, it says, I, the testator, to say my residuary estate goes to my spouse, to my kids, to my nieces and nephews, to charity, and maybe that's all there is to it, and that's perfectly fine. Because again, residuary estate is just everything that you haven't already provided specific instructions for. So maybe that's just, again, all of your assets all at once. Lastly, there's also a few more provisions that you're going to see in your will. Every will is going to have the appointment of an executor. So again, that person that you choose to be in charge of filing any necessary documents with the probate court. If you have little kids, chances are you have the appointment of a guardian for that minor child who's going to look after your child from a day-to-day basis after you're gone, and if the child is under 18. And a lot of wills also have fiduciary powers, a list of things that your executor is going to be authorized to do on behalf of the estate. Sometimes it's as simple as reiterating the state statute or referencing the state statute, where a lot of these powers are already identified. So it may just provide the name of a Connecticut statute. But some will say, here's a specific list of the things I know for a fact I want my agent to be able to do. And so I'm going to be explicit and list them out here. So I specifically give my executor the power to manage and sell real estate, to manage my bank accounts and pay bills, to handle any issues with filing tax returns or dealing with the IRS. So that tends to be a pretty common section as well, just because the executor needs authority to do all these things. And if you're not specifically granting them under the will, there can be confusion as to whether the executor has those powers. And in those cases where it's unclear, an executor may have to petition the probate court for approval to sell real estate or approval to do other various action items if, again, you haven't already specifically identified that you wanted them to be able to have that authority. So that's the video for today. If you have any questions or comments, please feel free to visit us at our website, kkc-law.com, for more of our contact information, to reach out to me directly, or on our YouTube channel here for all different videos that we have on various estate planning topics.